Council, ladies and gentlemen, everyone is present, I believe. We can continue with our sentencing. I think we're at the point where I can hear from the council. Mr. Myovis, are you set up and ready?
Yes, I am, Judge. So, Judge, I know you've said a couple times now that you have some questions, and I expect that this might be more of a dialogue than having me stand up here and speak for 45 minutes. So I'll talk about whatever you'd like to talk about, Judge. If at any point I get into a topic that I think I'm going to address, I'll let you know. But feel free, as you well know, to jump in, and I'll try to answer the questions as best I can. I'm going to start just very briefly, Judge, with the aggravators, because you had left off on that. And there were 5 aggravators noticed by the state, 4 of which were conceded by the defense in this case. The aggravators are the C4, dangerous instrument, C8, assault of history, C10, most serious, C18, DV assault, C20. He was on probation for a felony when the offense was committed. All of those have been conceded by Mr. Lambert in his sentencing memorandum, except for the most serious. You had indicated that you're going to want to talk to us a little bit about how they should be weighted. I suspect we're going to flesh this out a little bit more, but just from my beginning, I want to let you know that the state believes they should be weighted in this fashion. I actually, if you will, rank them in the order of importance that I believe you should place on them when considering what the appropriate sentence is. The one that's contested, the C10 most serious one, is, if found, going to be the one that I think should be given the most weight, because of the fact that our proposition is that this is actually a murder one scenario, and there's also a portion of which I'm asking you to consider finding him a worst offender and giving him the maximum sentence. So obviously all those things are predicated on that finding, and I would say that that would have the most weight, and we would ask you to give that the most weight. The second in this situation, Your Honor, would be the assault of history. I think that the history that Mr. ALMEDA has demonstrated in his very short lifetime has demonstrated a very serious assaultive problem. We would ask you to consider that as the second highest of the aggravators. The third would be the domestic violence assault, which is going to have some overlap with the assault of history. For the reasons, I won't reiterate them, that Ms. Winston stated when she spoke. The fourth would be that he was on probation for a felony when he committed the offense. This normally could be a situation that would be very heavily weighted by the court. And I'm not saying that you shouldn't give it any weight, Judge. You should give it some weight. But the reality is he was on release for a mix 4, as you know, which is an unrelated type of felony. I think if it were an assaultive related felony, I would be making an argument that you should be giving it much more weight. Obviously, the substance abuse issue that he suffers from and the history that we've talked about up to this point are the things you should consider when giving that weight. The last one is the dangerous instrument one. I think Mr. Lambert had argued that, yeah, that exists, but you shouldn't give it much weight. I think the case law is clear on that when it comes to a murder 1, murder 2 scenario, that you should find it, but the amount of weight that you should give it should be somewhat cautious about that, because most murders involve dangerous instruments. So that's the hierarchy of the aggravators.
I'm close to the same page as you on the order. Talk to me about most serious, of course, because that's where that and worst offender are where I have the questions factually, at least.
Okay. And are you asking me what my argument is for why you should find it?
Yes.
Okay. That's actually, I wanted to cover 2 major areas, Judge, and that's one of the 2 major areas, so I'll just go right into that. One of the things I'll tell the court, and I think Mr. Lambert would agree that this is a true statement, is that even when Mr. Lambert and I, in the very early stages of this case, started discussing the case, I was very candid with Mr. Lambert that I believed the state's theory was that this was a murder 1 scenario. And my scenario, my theory of the case, if you will, Your Honor, has remained the same. I know that I discussed yesterday some issues of murder-suicide yesterday with Dr. Zelig, It hasn't changed my theory of the case. I'm going to tell you what my theory of the case is. But those questions were relevant for other reasons. So, it's a murder one scenario, Judge, because despite, in a nutshell, what Dr. Zelig would testify to, did testify to yesterday, this was a domestic violence incident. This was very much part of his BPD and what he was experiencing when combined with alcohol, and it was very consistent with what he had done in the past. And all the evidence suggests that that's what happened here, and none of the evidence suggests that it was an accident. So my position is that it was an intentional murder. I'm going to talk a little bit about what it was that I think was the catalyst for what led him to point the gun at her in frustration or anger and pull the trigger. But I think the evidence here clearly supports that that's the scenario that happened. I want to take a step back, though, and explain this, Judge. We talked a lot yesterday about the alcohol problem that Mr. Almeida suffers from. So, even Dr. Zelig explained, and he reiterated, he needs to learn how to access his emotions without a bottle in his hands. Talked about liquid courage, social lubricant. This is important because of this, Judge. One of the things that we're talking about is this. It's the classic in vino veritas. In wine there's truth. With Mr. Almeida, that's when we see who he is. That's what we get whenever he drinks. This is not some sort of uncharacteristic trait that he has. In fact, that's when we see, when the affect is taken away. When this flat affect that we see, that we've seen throughout these proceedings, throughout this entire course of this case, that's when it's taken away, when he's drinking. That's when we see who the true Josh Almeida is. So in this situation, Judge, there's a couple of things I want to lay out factually for Your Honor that nobody's really talked about and explain why this is a murder one. So we all know that he just graduated from the anger management. There was a huge portion of substance abuse that was part of that anger management. I'm confident that you've reviewed those records. But sure enough, consistent with his prior behavior, he stops, buys a bottle of liquor, they get to the house. Now, here's the thing, Judge. The timeline here is important. We know that he bought the bottle of liquor sometime around 9 p.m. We also know that he and Bree get to the house at 10:04 p.m. Here's how we know that. If you look at if there's any question, you look at the records that I provided you of the text messages. One of the things that happens is both on Josh's phone and on Bree's phone at 10:04, they both uplink to the Wi-Fi that's the Almeida residence. That's our best indication. That's when they got there. They walk into the house, their phones immediately uplink to the Wi-Fi. We know they're there. We also know they're there because about 20 minutes later at 10:21, Miss Almeida sends the "What are you doing?" text message to her son down in the basement. There's no response to that. She says that she heard some noise. It stopped after she sent the text, so she didn't go down to investigate anything. Now, my proposition to you is not that that's when he shot her, that that's what she was sending the text, because it's important to note what Miss Almeida did after that. What she did after that was this, Judge. She went to the sauna. There's a sauna up in her part of the house. She went to the sauna. She took a sauna for a little while. She would have been in that closed room then. That would have inhibited her ability to actually hear a gunshot in the house. After that, she tells the detectives that she went in and took a brief shower. Also, a good chance that she wouldn't have heard the gunshot. Then she lays down. She's starting to fall asleep, drift away, and she hears, "Mom, Mom," downstairs. He doesn't come upstairs. She hears him yelling. She goes down to investigate. She finds Bree. Shortly after that, she calls 911. So, the most likely evidence here, Judge.
911 call was again at 12.
It's right around midnight, Judge. I don't have I don't have the exact, but it's right around midnight. It's right around midnight. So, we know that's the timeline we're working with. Bringing it back to in vino veritas. We know this. He drank almost an entire bottle of rum from the time he got there shortly after 10 o'clock until his mom goes down and calls 911, because that bottle of rum is almost empty under the bed when the police arrive. In a period of just under 2 hours, he consumes almost an entire bottle of rum by himself. Okay. The most likely scenario here, Judge, based on the evidence, not on a speculation, but the evidence, is that the shot happened. She heard some commotion downstairs. She texted him. She would have known if that was a gunshot. That wasn't a gunshot. But she didn't hear the gunshot. There's no reason to dispute that. So it probably happened when she was either in the sauna or in the shower, and she was unable to hear it because of one of those two scenarios. Well, that allows her time to get into bed and start to go to sleep, and then later be awakened by her son. So that means he shoots her, and she's down there for a period of time before he starts, if you will, getting frantic and alerting his mom to what happened. Now, I provided you some photographs, Judge, and I know that you had seen quite a few of the scene photographs and the photographs from the autopsy during the course of the reviewing the material that was provided. But the ones that I provided yesterday, Judge, are important because of this. There's a question of what position Bree was in when she was shot. Now, when Mr. Almeida told his story to Dr. Zelig, and he's told his story every other time, she was in bed waiting for him. He came in. She said, stop playing with the gun. He said, it's not loaded. Points, pulls the trigger. Look, it's not loaded. The problem with that, Judge, is that the objective evidence here doesn't suggest that she was actually laying in bed with the covers on her the way she was, where you find her in the photographs. The reason I provided you ones yesterday is because there's one real good indication that's not what the case was. She has the remote control from the TV, which is huge, laying right on her back shoulder, and there's so much weight being placed on it by her dead body that the numbers are basically imprinted into the blood print on the bedspread. So she wouldn't have been laying on top of that when he walked into the room. She wasn't laying in that position. The evidence actually suggests she was either standing next to the bed or sitting on the edge of the bed. She had her slippers on. She basically has that remote control behind her. There's no indication that she was actually laid out. And the positioning of her body itself is such that if she were laying in bed the way that the defendant has suggested, then her head would have been completely crushed up on her position of her body is almost in a curve, so she can basically fit on the bed without her head being scrunched up on the headboard. So she wasn't in that position when she was shot.
The crime scene photos I saw in the exhibits that you provided, most of those had her body covered with what looked like to me to be a bed blanket or some other cover that she pulled up over herself. Is your theory that that was placed on her afterward?
Yes, Judge. Yes, my theory is that whatever the situation was, she wasn't actually laying under the covers with her fur slippers on in the middle of June there's basically a comforter and a cover on top of that. She's laying in bed there. My position is that she was shot. I'm not saying that she was moved from one other room or anything like that. There's no reason to suggest that. The indication of where all the blood comes from is that she fell into that position shortly after she was murdered. My proposition is that then, if her legs were off the bed, which I suspect they were placed in the bed, she was covered up with the blankets, and there was a period of time that passed where Mr. Almeida, I don't know what he was doing down there, but he hadn't alerted his mom yet, or she at least wasn't aware of it yet. That happens later.
The one photo of her body in the exhibits that you provided me today, there appears to be blood smudge, for lack of a better word, under, that would be her right thigh.
Right.
Is there any significance to that?
There's two possible significance to that, Judge. The first one is consistent with what I'm explaining, is that there was blood present at the scene. Obviously, there was a tremendous amount of blood at the scene, and when the blankets were being placed on her, the pattern that you see is one that was created by some blood being sort of brushed along her legs as the blankets were placed upon her. This is one of those rare scenarios where there wasn't a lot of post-event movement of the body by the authorities, because it was very clear that Miss Moore was dead when they arrived, so they didn't manipulate the body. They did take some pictures when they went in. One of the things that is another possibility for that is that when the officers did begin to take the blankets off, that they are the ones that created it by taking the blankets off rather than somebody placing the blankets on her. But obviously it's something that happened in either event after she had been shot.
The 911 call is, of course, very graphic, and it's not clear to me where the call is made from, but what's is evident from the yelling that's going on is Mrs. Almeida is telling her son to stop touching or cradling or something Brianna Moore because she's passed. There's nothing he could do. Can't that account for the movement of...
Sure, it could. It very well could. And again, that would be one. That would be another scenario. I guess I said two, but that would be a third scenario. And there's no dispute on my part that he was at least at some point touching her. And one of the things that Miss Almeida says when she first is interviewed is that when she first comes downstairs, he's sort of at the bedside itself. And he is there next to her body. He's doing whatever he's doing. Yes, I assume that when I listened to the 911 call as well, that whether or not she is moved, I don't think she's moved. I think that we can see from the blood that she's not moved. There's at least some touching and probably some manipulation of the blankets during the course of that, during the frantic nature of that part of the event. It's not terribly significant of whether or not that blood was created by somebody in a post-event from the police or whether it was created by the defendant. My point is that she was probably shot sometime sooner than, well sooner before Miss Almeida found out about it, and she was alerted and she came down. So what I'm suggesting is that there was some, and let me just, so nobody gets the misimpression about this, Judge. I'm not saying that Josh Almeida intentionally killed her, was like, I'm going to kill Bree now, kills her, and then sits down there and tries to figure out how he's going to figure out how to explain that he's killed Bree. That is not my theory of the case. That's not what I think the evidence suggests. That's not what I'm saying. I'm saying that in a fit of rage consistent with his disorder, he got very agitated very quickly, and in a fit of anger, shot and killed her. And then, much like his disorder allows for, probably snaps somewhat back to some state of reality, and that's what we hear in the panic when we hear the 911 call. That's what's going on. So the other thing is this, Judge, when you talk about the 911 call, another thing is very, very clear from that. The flat affect that we see with Josh now, the flat affect you saw, I'm sure you watched the interview that he did about 2-3 hours later down at the police station. Completely calm. Completely, much like we've seen all along. Not like a man who just was in a situation where he killed his girlfriend. And no matter what scenario you adopt, he just killed his girlfriend. But he still has that flat affect, because that's part of the disorder that he has. Where he doesn't have it is on that 911 call. Because he's in an episode. That's what's happening there. He's in the midst of an episode when this happens. And it's brought on by the fact that he just consumed an entire bottle of rum in probably less than the course of an hour and a half. Okay? 2 hours at best. Almost an entire bottle himself. So, you have those factors, Judge. But you have a piece of evidence in this case that I provided to you. It's Exhibit 8. It's one of the, there was a series of text messages that I gave you that are marked as Exhibit 8, and they're called drinking texts. In the drinking text, Judge, one of the things that you'll see in each of those texts, and those are, again, a representative sample of the text messages, you'll see that Bree thought she could fix Josh. She would tell him, no more drinking. I don't like who you are when you're drinking. You're a different person when you're drinking. I know Mr. Moore referred to many of these texts in his letter to the court, and I know that you've seen those as well. But this one in particular, I think, is illuminating. So Exhibit 8, and I'm looking at the ones that are basically December 15th, 2013. At 3:10 on that day, Bree Moore texts him and says, "I told you I didn't want you to drink, baby. Do you remember getting grumpy at me last night because I wouldn't let you drink anymore?" "No, I do not. You're just different when you drink. I like you when you're sober because that's the true you, baby." Unfortunately, Bree has it backwards. The true you is when he's drinking. Now, the reason that's important, Judge, is this. We don't need to speculate. We know that Bree didn't want him to drink. He goes into that liquor store, the Tesoro, by himself, buys the bottle of liquor by himself, is drinking by himself. And that bottle of liquor is found under the bed in that room. There is absolutely no reason, no matter what scenario you think of, for that liquor bottle to be under that bed in that room in this event, other than Bree has decided to take that bottle away from him and keep him from drinking. There were bottles, Judge, I didn't provide all these photographs, but maybe it's in some. There were bottles stashed throughout his house where he was, I would assume, hiding the bottles that he drank from his parents. He put them in drawers, he put them in the closet. There were these bottles that were stashed, empty, all of them, except for this one. In the 911 call, at the end of it, Miss Almeida is describing him looking for something. He's looking for something. Now, Dr. Zelig says, well, Miss Almeida told me later that she discovered a long knife under the bed, and that's what I've been through all the photographs, Judge. There's no long knife that the police ever documented under the bed. You know what was under the bed? Is the bottle of liquor. The bottle of liquor. I hate to say that it's reduced to that kind of level, and it didn't make sense to me until I started reading the literature on the BPD. But the fact that somebody had taken his liquor from him is exactly the kind of thing that would set him off in this state. She had done it before, and when she says grumpy, Judge, one of the things that Bree often, she never used terms that were harsh or derogatory or even judgmental. Her terms always had a softness to them. No matter what, you can look through some of those texts, when he starts referring to her in very derogatory terms, she will say, "Why are you so grumpy?" That's her term, grumpy. It doesn't matter how mean he is to her, her term is grumpy. He was grumpy to her when she took the bottle away the last time. That's been my theory since day one, Judge. There's no way to explain why that bottle's there, what's going on, other than the fact that Bree absolutely, most likely, took that bottle away from him, and that's the catalyst that we're dealing with here. But I'll point this out to you, Judge. It doesn't matter whether or not anybody says, yeah, that's definitely what happened. You know, obviously, one of the things Mr. Moore has been opining for a year and a half, 2 years now, is that there was an argument about whether or not they were going to move in together, or whether or not they were going to stay together, or what the future held for them. That set him off, and he killed Bree because of that. It didn't make sense to me until I actually sat down and started reading the studies about, this is my first case where it's such a clear example of the mental health issue that the person is suffering from. I have absolutely no question that he's properly diagnosed by Dr. Zelig. But everything you read about that is that it doesn't have to be any rational catalyst for a person to enter that episode of anger, the fit of rage. If that's what the disease is, that it's all in their mind. They basically think somebody's going to leave me. They think something's going to happen bad. They do something that is absolutely, from the outside world, irrational. And they do it because they have this disorder. And his is exaggerated every time he drinks. In vino veritas, every time he drinks, something bad happens. Now, as Dr. Zelig pointed out himself, all the assaultive conduct that we dealt with in the past, all accompanied by some sort of drinking or some sort of substance abuse. That's what happened here. There's no reason in this situation to think Josh acted any differently than he had in every every one of the other situations. And you could say, well, yeah, but Paul, didn't he try to hurt himself more than he hurt others? Well, sometimes. Sometimes he threatened self-harm. But sometimes he lashed out at other people, including police officers. There's no rhyme or reason to that. The thing, I was getting a little anxious, maybe visibly so, when Dr. Zelig started talking about this. I objected, Judge, to that. There's no indication that this was domestic violence. I find it amazing that Dr. Zelig would offer that opinion, and he actually offered it by backing it up by saying, I didn't see any pictures of Mr. Almeida, but if I saw pictures of him, I would look for things like defensive wounds on him that I would see in a classic domestic violence situation. That's what I would be looking for. I didn't see any pictures, but I don't think there were any of those. Therefore, I don't think this is a domestic violence situation. That's one of his propositions. It is outrageous to me that that would be a seriously taken proposition. The defensive wounds exist, but they're through Bree's forearms. Those are defensive wounds. You don't have defensive wounds on a defendant that's standing over somebody with a gun pointed at them. That's not what happens. Those are defensive wounds. The defensive wounds that he's talking about do exist in this case, but they're on the victim, Bree, because she was trying to protect herself from her assaulter, Mr. Almeida. If you look at the position from the autopsy photographs and you look at the photographs from the scene, it will become, I think, clear, Judge, that she's most likely on the side of the bed, has her arms raised in front of her. He shoots her, she falls back on the bed. That's where she comes to rest.
Isn't it accurate for Dr. Zelig to say essentially that you might throw your hands in front of your face whether or not the person pointing the gun at you is acting recklessly, not knowing whether the gun is loaded or not, or acting intentionally knowing that the gun is loaded and intends to shoot you? You're still going to have the same reaction if a gun is pointed at your face. Throw your hands up to protect yourself.
I disagree, and let me explain why. If somebody were, this scenario as explained is, look, it's not even loaded, points, pulls the trigger. Maybe you would get a hand up under that scenario. Maybe that's what would happen. No, don't point the gun at me. Don't do that. We have full-on defensive wounds. The thing that you may not know about this, Judge, I still find this amazing to this day, is that because her body wasn't disturbed at the scene, nobody knew that she had the defensive wounds in her arms. We actually thought we might be dealing with some other kind of scenario.
I remember that.
And in this situation, even the medical examiner, when he saw those wounds, it's textbook. That's the thing that's so amazing about it. There's two textbook aspects of this case. One is Josh Almeida is a textbook example of BPD. The other one is this is a textbook example of a DV homicide. She has the defensive wounds that you talk about, you study, you hear about these things, but you don't see these things in your case because people don't normally have the time to get their arms up in that manner to protect themselves when they're shot. Sometimes in the fingers, sometimes in the hands, sometimes through sort of a graze wound to the arm, but never both arms in front of their face. Goes through both arms and hits them in the head.
You provided with your sentencing memoranda some forensic reports, and one was from Bob Shem. Do I remember that he concluded that there was gunpowder stippling on the shirt she was wearing on the arms where the bullet went through, or at least the first arm, indicating that she was shot at what I would call close range. I think he used a different term, moderate range maybe, but something like 12 inches?
Right, that's right, Judge. So that's one of the other things that we commonly look for. I know that you know through your experience in the cases, whether or not there's stippling will give us some indication of how far away a person was. Again, his version is she's laying in the bed, he walks into the room. Look, he would have been standing over on the side of the bed, would have done that. They wouldn't have been within 12 inches of each other. She wouldn't have that kind of stippling. She's up on the side of the bed. That's how that happens, Judge. Who knows what they were arguing about or what he was yelling at her about or whether or not he was even yelling or if he was just pointing the gun. But the scenario he paints is not supported by the evidence at all, including what you just pointed out. I want to go back and address one other thing about Dr. Zelig with whether or not it's a fair comment for him to say that. When he interviewed Mr. Almeida in his 3-hour interview, I watched that, Judge. He asks him this very question. Well, people are going to be a little bit curious about how she got shot through both forearms. How did that happen if what you're telling me is the scenario is a scenario? That doesn't seem to make sense. He even knew that that didn't make sense. Josh says, well, that would be a normal person's reaction to having a gun pointed at them. And that's it. They move on. Okay, that's good enough for me. Check the box and move on. Judge, I asked him about Dr. Raskin and about the polygraph yesterday because of this. Not 6 months ago, I had a scenario where Dr. Zelig was testifying and he had the same thing going on, but it was a sexual abuse of a minor case where the defendant was saying, no, I didn't do this thing, but then they had the investigation and said, you did do this thing. He wasn't able to reconcile it. He had the person take a polygraph. He had the person take a polygraph so he could know, is this person actually telling me the truth? And we talked about all the memory things. It doesn't mean that that's necessarily the truth. It just is that's what they believe the truth to be. I know you're well aware of how all those dynamics work. I'm not going to belabor it. He did nothing to test the account that was given to him by Mr. Almeida in this case. Nothing. Less than nothing, because put the polygraph aside, the fact that he didn't look at any of the text messages between these two individuals that existed for the last 1.5 years of their lives is the best piece of evidence that he could have looked at for collateral support. Didn't even consider them. Didn't even consider them. It's just garbage in, garbage out. And I have a lot of respect for Dr. Zelig. I know that he's a very good psychologist at what he does. But this is one of those situations where he's got the diagnosis correct, but he is absolutely wrong about the scenario that happened here. And it's because he didn't vet seriously enough the information to find out what really did happen. He said, well, that would be a natural reaction. People would raise their hands. He said, okay, check, moved on. Not another question about it. We talk a lot in cases about consciousness of guilt. So this is another thing that indicates that Joshua murdered her and he knew it wasn't an accident. There were 2, maybe 3 hours worth of interviews overall over the space of time for Mr. Almeida down at the police station. The police in this situation gave him every opportunity to offer a reasonable explanation for what happened. They gave him the accident lifeline. They gave him everything. The thing that's very telling about this is whether or not he remembers what happened. He knows one thing. He knows that gun's his. He lies and lies and lies until he's confronted with, well, we're going to have that gun tested. We're going to look at DNA on that gun. The wheels start spinning. He realizes, okay, they probably got me on this one. There's no way around it. So he gives it up. He gives it up. When a person is caught in a lie that there's absolutely no way they're ever going to be able to explain, they give it up, like Josh did in this situation. He also knew that even though he claimed the gun ultimately, he didn't give them anything that would explain what happened in that room down there. So there's one of 2 possibilities, Judge. One of 3 possibilities. One, he doesn't remember. At that point, as he's sitting in that room right there, he doesn't remember. And whether or not he has a sincere feeling now about the accident scenario that he's provided, whether or not that's truly what he believes, he may have formed that later. So maybe he doesn't remember. 2, he does know what happened. He does know, and he's not telling them because he knows what he's going to have to explain. And there's no good explanation. Okay? Or 3, he knows, but he's scared. He doesn't want to talk to the police. But the problem with that is that doesn't really make sense in this case, because if somebody's scared of the police, doesn't trust the police, doesn't want to talk to the police, he's been through the system, Judge. He knows the drill. He didn't have to talk to them, but he's talking to them and he's lying to them. It's this consciousness of guilt. Whether or not he's lying about what he remembers or doesn't, we know he's lying about the gun. The one thing that's very clear, he's got consciousness of guilt. When you look at all of the evidence in this case, and one of the things you should consider is all the 404B evidence, the assaultive conduct, the assaultive history he has, his disorder and how that would play into the scenario. It's inescapable that the scenario is he had an episode, he got extremely angry extremely quickly, he pointed the gun at her, and he intentionally pulled that trigger. Now we can parse out, Judge, whether or not, well, in order for it to really be murder in the first degree, somebody has to inform the intent to take that person's life when they commit the act. Well, we know in Alaska law that there's no period of time that a person has to have that in their head. And we also know that in this situation, a person's natural consequences of their action can guide your decision on what the evidence is here. Obviously, if you point a gun at somebody with their arms up in front of their head and you pull the trigger, shooting them through their arms and into their head, your intention is to kill that person. There's no other intention that can fall from that action. Your arms aren't going to prevent that bullet from coming through. I would suggest to you, Your Honor, that there is no evidence to suggest it's not a murder one scenario. There's simply not. In every murder case, we deal with circumstantial evidence. We deal with the other evidence that basically would lead to a person to 404B, these things. These are what we look at in murder cases, because typically it's two people. There's nothing in this case that would suggest that this is not a murder in the first degree. So that is the state's position. If you have further questions, I'd be happy to address them, Judge.
I do. You submitted 3 photographs of blood pool on the bed after Bree's body is moved. What's the...
Those were to show that remote control was laying on the bed in the position that she was in. That's where I started, because she wouldn't have been lying on top of that remote control in that way. That's why I did that.
Okay.
It may not have been clear, but there's an imprint that you can see from the numbers where the remote control was obviously under her after she started to bleed. Any other questions, Judge?
No, certainly not on the most serious issue. And if you want to talk about history of assaultive behavior and worst offender finding at the same time, you can, because they kind of go together.
Judge, that's actually an area that I thought, based on the 404B application that you thoroughly reviewed and made your decision on, all the pleadings up to this point talking about his assaultive history. I hadn't planned on talking much about the facts of that. I feel like the court has all the assaultive history laid out for it. I don't think that in the remaining time that I need to spend a lot of time discussing that. I'll rely on the stuff that's been submitted to the court.
I guess the one question I have is, although I know the law is that worst offender finding can be made just on the nature of the offense, the logic of a worst offender finding for a defendant as young as Mr. ALMEDA.
I understand that is the struggle, Judge. I clearly understand that that's one of the biggest challenges in this case, that Mr. ALMEDA was very young when he committed this offense. He's been incarcerated for the last almost 2 years now. What I would answer the court, I cited cases in my sentencing memorandum where there were other, I think, similarly situated young offenders. And one of the things that I think in those cases that they looked at were what we were dealing with mental health issues. I believe that one of the cases dealt with a young man of a similar age that had mental health issues, had substance abuse issues, and had a history, I think, slightly worse than Mr. Almeida's history up to this point, which included some juvenile history that Mr. Almeida doesn't have. And the court found that that was sufficient based on the facts of that case, even with a useful offender, to find that he was a worse offender. What I would point back to is this, Judge, is that Miss Winston said this, and this is always something that's difficult to deal with, which is, how do you treat a defendant like Mr. Almeida with all the resources and all the family history and all the support and all the opportunities he's had, when most people sitting in that chair in this situation don't have those things, don't have the ability to go get the treatment, don't have the ability to avail themselves of a stable family lifestyle, have a job, all those things. All the things that should work in his favor had no bearing at all in the situation. I think he's a worse offender because of this, even though he's very young. By the time he reached 19, as I lay out in my sentencing memorandum, and I know you're well aware of, there was not a single day of his life from that point, from the first time he got in trouble when he was 19 until he committed this murder. In fact, there was often overlap. He was often in violation. He was often in situations, and that's just the stuff we know through the case investigation here. We know he committed many more offenses, many more felony drug offenses while he was on those releases. There's a myriad of things that he did that he never got caught for, all felonies. So yes, he's young, Judge, but he has demonstrated nothing but the fact that he is not amenable to any sort of supervision at this point. And as you pointed out, the law is clear that the facts of a case itself can warrant the finding of a worst offender. This is one of those situations where you could find it based on what happened here, assuming that you find that this is tantamount to a murder in the first degree. You would have to make that finding in order to make the further finding that he's also a worst offender. But his history, I think, supports the finding. His mental illness supports the finding. The fact that he has been in so many treatment programs right at this point and has never availed himself of those supports the finding. One of the things that I always try to be very, very respectful of the family, because I know that the family should not suffer for the son's sins. I strongly believe that. But Ms. Almeida said that he was asked to not go through the treatment at Prov until he got his substance abuse situation straightened out first. You got the records of that. You saw those records. I read those records in a very different way. I read those records from the perspective of, mind you, Judge, we're talking about May 2012, 2 years before Bree is shot and killed. He was diagnosed then. How many people are sitting in Mr. Almeida's situation that were actually diagnosed of their mental illness 2 years before that, had all the resources to address it, and didn't? Very rare. It's very rare. They knew what he needed. It wasn't that they told him, you go away and come back when you got your substance abuse straightened out. He didn't want to go to inpatient. There's that note in there, Judge. I don't know if you recall this or not, but his dad said, we have insurance. We can send him to an in-treatment facility. Josh didn't want to do that because he wanted to work, wanted to make money. He's never wanted to get his therapy under control. I provided some of those documents from his journal from the Volunteers of America DUI therapy that he went to, and one of the things that's even clear there, I'll give him credit for being honest, but he says therapy's a joke. He's getting nothing out of it. He says it a couple times. He's angry that he has to go to therapy. His goal, when he got to the Aquila program, his goal there, he said, my goal for therapy is to not have to go to therapy. Not my goal for therapy is to get better. My goal for therapy is to stop drinking. My goal for therapy is to deal with my anger management. None of that. My goal for therapy is to not have to go to therapy. Miss Winston said past behavior is indicative of future performance, and that's what you should look at. I agree with her that that's a very strong indicator of Mr. Almeida's future prospects for rehabilitation. But I would also suggest that it's not even past in this case, it's present. It's present. He knew he was going to be sitting here someday in front of you in this situation, being sentenced for a murder that he committed. 2 years he's been in. Dr. Zalik asked him, what treatment have you been getting since you've been here? He laughs about it. He gives an awkward laugh. He's like, no, there's nothing. I'm not doing anything. There's no indication that he's going to take therapy seriously, none. And one of the things that's really challenging here, Judge, is this. You know, I asked for a parole restriction in my sentencing memorandum. I stand very firmly behind the fact that I was going to talk about the chain of criteria. I'm going to address them very quickly here. Everything I'm talking about today, I think everybody else has addressed many of the chain of criteria that you need to consider. The ones I'm focusing on are the seriousness of the defendant's present offense in relation to other offenses, the prior criminal history of the defendant and his likelihood of rehabilitation, and the need to confine him to prevent further harm to the public. In particular, I think that you need to give a lot of weight to the need to confine him. He has had more opportunity than just about anybody that will come before you to address his problems. And he's never addressed them. And he has no intention to do so. Even now, he hasn't availed himself of any sort of help to come in here and say, I'm taking this seriously. I provided you some statistics from the parole board. Okay? My argument for the most serious worst offender is that you find him most serious offender, you find this a most serious crime, you find him a worst offender, you impose the 99-year sentence, and then he's eligible for parole in 33 years. When you do the math, given his age, he'll be about 56 when he's eligible for parole. Now, I asked for the additional parole restriction as well, Judge. I'm going to lay out so you understand that this is a well-considered argument. I've never asked for a parole restriction in any case before this. Here's the thing. Mr. Moore was a little bit correct and a little bit incorrect about what the legislature is considering doing. He said that without the parole restriction, they could allow him to be released at 55, even if you give him a 99-year sentence. That's actually not correct. Even if you give him the parole restriction, if the law is passed in its current form, it says, notwithstanding any parole restriction or other. So even if you gave a parole restriction, it's going to be advisory at best. And that is the primary reason I've asked for it, because of this. In the current light of this situation, there's a line that I think explains very clearly where we are in the criminal justice system and penology and what we're doing. And it's this. We need to figure out who we're mad at versus who we're afraid of. Well, we may be both in this situation, but we should be afraid of Josh Almeida. And in fact, Dr. Zalik tells you right now, everybody should be afraid of Josh Almeida if he's released. We have no reason to think it's going to be any different in the future.
Well, I know that's true from what he says right now, but at least some of the literature that was provided to me says there are good prospects for remission with BPD, and he's only going to get therapy for that on supervised release. He's not going to get it in prison, I don't think.
Well, I think that that's a very realistic expectation as well. And even any therapy he does get in prison, Judge, is going to be something that he initiates. I mean, that's the, as you know, the way our Department of Corrections works, the way our law in Alaska works, is that he's not required to do anything. It's up to him. So this is the reason why we should be so concerned. That is actually what I have on the PowerPoint, Judge. So if you don't mind, let me go ahead and... Could you drop the lights a little bit, please? Okay. let's talk about that. You're right, Judge, that some of the studies say that there is some indication that a person can get better. But I want to cover the highlights of the studies because of this. First of all, the thing that I think needs to be remembered is that all they're talking about is a person no longer has BPD. That means they fall under the threshold of 5 of the 9 criteria to meet the disorder itself. The 2001 Trampler study, that was just 3 individuals, they were all over 50, and as they said, that in that situation, when they basically faced actual or perceived loss, they actually put steps backward in that situation. I'm going to go through these fairly quickly and hit the ones that really address your point, Judge. These studies, the 2003 Zanarini study, what is clear in these studies, Judge, is this. Yes, they may fall below the threshold to be diagnosed with BPD, but there are certain traits of that 9 criteria that persist even in older age. And they're the ones that we should be concerned about with a person like Josh Almeida, Judge. So that one's explaining to us that, yes, some of the traits over the course of the 6-year longitudinal study decrease, but others don't. And I'm going to get specific about the ones that don't with the later studies. Yes, he may stop using substances to the extent that he does. He may stop being suicidal and have ideas of self-harm. But what this tells us is that he still has a 65% verbal outburst, eating binges, the impulsivity dealing with speeding sprees, the things that basically show acting out. He's still going to have those things. It's actually more important. I'm just going to fast forward, Judge. These studies all, I think, say the same thing. But this chart and the Morgan study from 2013, I know it's very small up there, but it's at page 1511 of the Morgan study, the 2013 Morgan study. Previous research shows that as opposed to acute behavior symptoms such as suicidality, temperamental symptoms of BPD such as dependency and anger are more stable over time. And their chart shows this. More stable over time, anger. That's the number one, Judge. If you look at that chart, there's 2 columns there. And I know the numbers are very small, so I'm going to be very clear about this. The situation with these studies, Judge, is that clinicians talk about reduction over time, but it's a statistical reduction, so you have to look at what they're really talking about. So in the one age group of 18 to 25-year-olds with BPD, which is where Josh would be right now on the outlier, the incident of anger among the people they studied was 82.5%. But when they went to the 45 to 68-year-olds, it actually increased to 84.8% of people with BPD. The affective instability. In the smaller group of 18 to 25-year-olds, 94.3% in that group. Yeah, it reduces, Judge, in the older group of 45 to 68, but it only reduces to 82.5%. 82.5%. Anger. Affective instability, impulsivity, goes from 74.2% in the younger group to 54.3% in the older group. All of the things, all these studies say the same thing, Judge, is that there are certain traits that persist throughout a person's life. This chart that I have here is based on the testimony that Dr. Zaley gave. So there's a couple of fonts, if you will. And Judge, these are 1 through 9. That chart is 1 through 9. It follows the
Right.
DSM-5. These are the ones. The ones that are in bold, which are all of these, are ones that Dr. Zaley said that he has. The ones that are underlined are the ones that he has serious symptoms of. And then I put the incident in the older population percentage that still have that in the margins there.
Is that still having that after treatment? Or is that just still having that after age?
So the
Judge, one thing I think that needs to be made clear that Mr. Myotis is not telling the court is that when he talked to Dr. Zelig when we were in his hotel about it, Dr. Zelig explained to him what that chart meant and that he was actually reading it incorrectly. And I think the information he's providing you is not exactly what Dr. Zelig says that chart says and what the studies show.
Let him answer my question, and you can address it when you get up, Mr. Lambert.
I'm sorry, what was your question, Judge? Treatment or no treatment?
Is that having,
That
still
study-
having those symptoms just after age or after age and treatment?
That study doesn't have an indication whether or not the person was being treated or not treated. One of the other studies that I provided actually says in the methodology that all the people in that study were
Right.
being treated during
Okay.
the course of that. And here's the difference is, Judge, is that, look, all due respect to Dr. Zaley, he could tell me I'm not reading this report. I'm an intelligent person, you're an intelligent person, I can read this report, I've read many similar reports. He said that they're both longevity studies. He's wrong about that. This Morgan study is not a longevity study. This Morgan study is they took a group of people in one age group that had BPD, they looked at them, they looked at their symptoms, they looked at those things. They took another group that was in the older age group,
Right.
and they looked at, not a longevity study.
Right.
He's wrong about that. And this is what that shows. That in the people that still have BPD, and I'm addressing exactly the question you asked, Judge, which is this. Isn't he going to get that treatment after he gets out and he's on release? Because that's the only realistic way he's going to get it. Well, what I would suggest to you is this, Judge. We could do it that way, but he's going to be very dangerous when we do that. Because he's still going to have, even if he's in his 50s or 60s when that happens, this chart.
Isn't that an
This
argument for an earlier release than a later release?
No, Judge, because everything in the chain of criteria in this case, put aside his mental illness, put aside all those things, everything in the chain of criteria in this case would warrant, even if it's not a maximum sentence based on a worst offender finder, based on similarly situated defendants with similar history and the similar events, a very serious sentence would be warranted under all of the chain of criteria in this case. So we're not, what I would suggest to you is, we're not even dealing with when you treat Josh equally among people who've been convicted of murder. We're not talking about a situation where he's going to be, if he's treated fairly, eligible for parole at the kind of time that we're talking about, the kind of age that we're talking about. We can all do the math, Judge. We know we're working thirds here in murder scenarios. You could give him 60 years flat, and he'd have to do 20, he'd be out when he's 45, 44. You know, that's, I mean, obviously I don't have a crystal ball, I don't know what Your Honor's thinking. I think that would be an extremely low case for his history and for the event here. It would be, to me, completely uncharacteristic of this sort of crime for him to get 60 years. So we're talking about, my estimation is, Judge, something in the upper range of the sentencing. So he's going to be in his 50s. Even if he's released at the first parole board hearing ever, he would be in his 50s. And he would have these conditions, and they would be, as Dr. Zaley said, could be worsened. They would be exacerbated by the fact that he would have been incarcerated for the last 20 years. We all know, I'm not going to put my head in the sand about this, Judge. Our criminal justice system is not set up to reform people. He's going to be institutionalized. There's every indication that he's going to be in a worse spot in 20 years than he will be right now. We're not prepared to let him walk out the door. I don't think anybody is prepared to do that. He's going to be in prison for a while. He's going to be institutionalized. He may regress. He may be worse then than he is now. And then we're going to let him out?
and just let them do outpatient treatment on him at that point, he'll still be dangerous. That's what these studies show. Still be dangerous. 84% on the inappropriate, intense anger, chronic feelings of emptiness, 84.8%. That's the older age group. He's still going to have all that. He may not be diagnosed BPD anymore because he won't have 5 of the 9, but he's still going to have some of these if we look at it statistically. And that's always the tricky thing, right? Even Dr. Zaley says this. I can't tell you that groups of people are going to necessarily reflect specific people, i.e. Mr. Almeida. So that's the easy way of saying, even in the best case scenario, if you take all this data most favorably to Mr. Almeida, I'm not saying that's what he's going to have. That's a statistical analysis. We don't know what's going to happen to Mr. Almeida. We know he's got a very severe case of BPD, and we know that he's very dangerous now. I want to just address, in the larger sense, because you just asked about whether or not it would warrant him being released earlier. I think I've gone.
Don't worry about the time, Mr. Myovis.
Okay. I thought a lot about the parole issue, Judge. Like I said, I've never asked for a parole restriction. In fact, I'll be quite frank about it. It's brought me and Mr. Moore to loggerheads many times over the course of the last couple of years. I started researching this. We've created a moral hazard in Alaska with the way we treat parolees. It used to be the law, and you've been practicing in this jurisdiction way longer than I have, so you may be aware of this. There used to be a case that was Neocock back in the 80s that basically said that there was some liability for the parole board when an offender got out, offended, and harmed somebody. And then in 2006, the Supreme Court in Cowles, which is 151 P3rd 353, reversed that decision. And they said, unless you knew the person was dangerous, there's no liability. The state, and I understand the irony here, Judge. I mean, I am the state. I'm standing here, I am the state. And what I'm telling you is that that role is absolutely insane in these scenarios. It makes no sense. The one entity that we're going to trust to make the right decision in the future has no accountability. None. There's zero accountability for the parole board. They'll be completely immune. They don't have any incentive to get the decision right. In that case, it was the worst case scenario. I talked a lot about murder-suicide yesterday because, sure, there's an aspect of maybe that was one of the aspects of this. He clearly was suicidal when we hear him on the phone. Whether or not he formed that intent as he shot her, before he shot her, or after he shot her, I don't know, but he was clearly suicidal. What concerns me more is this. People with BPD, this is one of the characteristics that they have. In this case that reversed the immunity situation for the parole board, that was exactly what happened there. The parole board released a guy that was a dangerous person, and he did a murder-suicide scenario. And ultimately, the Supreme Court says state's immune from any sort of, parole board's immune from liability in that situation. We've created a moral hazard, Judge, in the state of Alaska. We can't rely on the future goodwill of the parole board when they're not going to have near the information that you have right here today when sentencing Josh Almeida. As I said, if the law passes, even if you gave a parole restriction, it would be advisory at best. And the reason I think that's important is because of this. It would give the parole board one additional incentive to really pay close attention to Mr. Almeida's situation before releasing him. It would give them one more reason to really take a good hard look. You know, the other thing that is just alarming about the way the parole situation is set up in Alaska is that there is a list of things that they have to consider and things that have to be done when considering somebody for discretionary parole. It is not obligatory at all that a person like Josh Almeida is psychologically evaluated. before he's released. And as you suggested, the treatment is not going to happen while he's in custody. They're not going to have him evaluated. They're not going to know how dangerous he is when he gets out. They're going to put him on the street, and we're going to find out the hard way. I didn't set that up, Judge. That's the way the parole board is set up in the state of Alaska. The thing that, and I'll probably just end on this because, unless you have questions, Judge, because I think this is really it in a nutshell. You know, Dr. Zalig uses the weather analogy. And we did meet and we did talk. And, you know, I have a good working relationship with Mr. Lambert, and I've worked with Dr. Zalig, so it was a rather cordial meeting. And we talked about that analogy, and he brought that analogy up with us. And he sort of looked at me and said, why do we do it this way? Why? Why do we do it this way? You want to know if he's going to be dangerous in 20 years? Call me in 20 years. I'll evaluate him. We don't do that, though. We call him at sentencing. Parole board doesn't call Dr. Zalig. It says, Dr. Zalig, why don't you come down here and evaluate Mr. ALMEDA before we release him? We need to know whether or not he's going to be a danger to the community. We don't do that. That's what we should do, but that's not what we do. And there's no indication that Mr. ALMEDA has given anybody up to this point in his life that we should just trust in 20 years that he's going to be all cured of his illness, safe to be put back on the street, and let him go out and get whatever treatment he needs at that point. That's not what should be happening in this case, Judge. Look, obviously everything is in your discretion. What I would say to you is this. I think the hard decision really is, how long does Mr. ALMEDA have to stay in prison? I mean, we all know that it's going to be quite some time, and I know that you sentenced far more murder defendants than I prosecuted, so I trust your judgment. I've told the Moore family that you're going to make an intelligent decision. But this is a dangerous man. Isolation is important for him. All of the Cheney criteria warrant a very high sentence in the presumptive range, Judge. He committed a murder 1, this is not a murder 2. You should sentence him to 99 years. Whether or not you give him a parole restriction, obviously that's well within your discretion, Judge, but if you think that that's not wise, I understand that as well. If you don't give him a parole restriction and you give him the 99, with the new rules that the legislature is setting up, if it passes, he's going to be eligible for parole at 55. Is that justice in this situation? I don't think so, Judge.
One last thing, Mr. Maiovis, and you know, I think you need to address this in speaking for the public, because so much of the public has spoken beyond the Moore family in this case. You mentioned a few minutes ago the distinction between being, quote, afraid of a defendant and being mad at a defendant. And I worry that everyone's just mad at Mr. ALMEDA in this case. You know, it's I do personally value life the same, whether the loss is a beautiful, sparkling 25-year-old woman or an alcoholic on 4th Avenue who's murdered. It's the same loss of life, it's the same crime I have to sentence, and the defendant can act just as culpably in both cases, and I don't give somebody a harsher sentence because one victim is more beautiful than the other, and one victim is more popular than the other, and has, you know, reached more people and has more friends who can speak out in a courtroom. And you know, I worry about that. And would you be making the same argument on behalf of the community if Josh ALMEDA's BPD resulted in him swing a bat on some drunk on 4th Avenue?
I'd like to think I have enough integrity that, yes, I would, given his history. My argument is not, I've spoken for an hour and 15 minutes now. I haven't talked about justice for the family or any of the issues that are I'll be frank about it, the more emotional aspects of this situation, the things that people are mad at him about. I'm trying to address this in terms of what he did and why we should be concerned about him being in the public, in the community. I think those are the things that warrant the sentence for Mr. ALMEDA. And I strive very hard to avoid, as the state's representative, as a prosecutor, treating anybody differently, given the scenario. I have not prosecuted somebody in the past that is so clearly and clinically dangerous as Mr. ALMEDA. I'll be frank about that, Judge. Maybe you have. Maybe you've sentenced somebody that has been such a classic example of a personality disorder, and a dangerous one, a very dangerous one. And there's no drugs you can give him. There's no quick therapy sessions he can take. This is a persistent problem that's going to be with him for his life. So my argument is based on that. And the track record that he's had up to this point. He's had opportunities. He's had opportunities. He is in that category of people we should be afraid of.
Okay.
Judge, I'm gonna start there, I think. I have had numerous conversations with my wife, who is an investigator, worked on this case, and has worked on every one of my cases for the last decade. She has a tremendous amount of experience. She has a master's degree in marriage and family therapy. And we've discussed a lot about this. And the one thing that was said, and you said it out loud, Judge, and I think a lot of people are afraid to say it out loud. I'm going to phrase it this way. I have done a lot of sentencings and a lot of homicides over my 30 years of practicing law. I can only recall one time the state has ever asked for a parole restriction in any one of my homicide cases. It was a first-degree murder case of a person, Marlon Mack, who had a way worse history, and he's got a published opinion than Mr. ALMEDA, and it was a domestic violence killing. It was way egregious. And quite honestly, the question that I got asked is, would the state be doing this if this wasn't a white woman from a rich family? Has been in the public eye and has been out there with Breeze Law and has been making the public aware by putting letters on Facebook and getting as much information to you as humanly possible to be done. And I think that is something that is a concern in this case. And I'm glad you said it, Judge, because my experience with you has always been you treat every person the same no matter what. And you try to look at similar circumstances and sentence accordingly under similar circumstances. And that's what I think one of the things that has been in this courtroom, but no one's been willing to say it until you said it just a few moments ago. And I think it's something that has to be a factor. And Mr. Myovis's phrase that he used came from Dr. Zelig, who said it the other day when we were meeting about that. That's where he got the mad and the scared. And I think people are mad. I think there are some people that are scared too. But I think the majority of the people are mad, and they're trying to sway you based on anger. And they're trying to get you as angry as they are. And I know you won't do that. And I'm glad you said that. So I want to look at this, Judge. The state has argued this is a first-degree murder case. I know from doing this for a long time, it is easy to go to a grand jury and get those people to indict on pretty much anything you want to. I think I actually got quoted in the paper once saying you could indict a banana if you wanted to. It's not hard for them to go. They are the only people that are there. It's the state, it's the grand jurors, it's the witnesses, it's the clerks, and it's jury instructions that they give them. It's not hard to present evidence to them to get, and we often see the state will go ahead and indict on a greater charge with the idea of, hey, we can get a plea out of this, on a lesser charge instead of going to where the charge should actually be, because then we know the defense attorney is going to start asking for something like manslaughter in this case. All right, and I'm not saying this is a manslaughter case. That's not what I'm trying to imply. The implication I'm getting at is the state often indicts over charges on cases. I don't see this as a first-degree murder case. I think that this is a case where the evidence, I don't think we really know what the evidence shows. And here's what I'm going to say about that. This homicide case that I was doing down in Kenai, the one I was supposed to be in right now, the state's argument, I'm going to lay out just a little bit because I need to make this point. The state's argument was that my client essentially beat this person, hit him with an ice axe, and then that person crawled into the bedroom on their hands and knees, and my client shot him with a shotgun, and the shotgun jammed. Then he went and got a 30-06, and then shot him a second time with a 30-06. That was the state's theory for 2 years, till we hired a crime scene reconstruction expert. And oh my goodness, was the facts of the case completely different than what everybody thought it was. We all had different theories. The crime scene reconstructionist, I hired 2 and the state hired 1. That is what led to the resolution in that case to a manslaughter as opposed to a murder one. But the point that I'm getting at is everybody thought the evidence was one thing in the case, and the crime scene reconstruction experts, even the states, came back with something completely different, and the officer and the district attorney's view of the evidence in the case were wrong. We don't have that here. What we have is a theory by the state and a theory by the defense. Blood tells a story of its own. Reconstruction experts can reconstruct events from those things. That's never done here. I spent a ton of time with these experts over the last few weeks in preparation for that trial, and over the last few months learning about this stuff. And I think I can fairly say that if his theory is she was standing up or seated on the edge of the bed and she shot through the face right there, we're seeing a different blood-stained pattern than we're seeing in this case.
Okay, maybe the state's theory is not quite accurate, but there were 2 things that struck me when I reviewed the materials that were submitted to me when I reviewed them this weekend that just stuck out at me as something that made this look more intentional than reckless. And they were these. First, Shem's forensic report that indicated that this was a shooting at what I would call close. You point a gun that close to somebody to leave gunpowder on their sleeve, you're getting real close. You gotta, in my view...
I think it's up to about 18 inches.
Yeah, well, even 18 inches, I mean...
Understood, a foot and a half.
That's, you know, you're intending to really scare that person, or you're intending to do some damage. Secondly, and I felt this way when I read Dr. Zellig's report and Mr. ALMEDA's explanation to him that this was, he thought the gun was not loaded, and he pulled the trigger and it went off. You know, I don't know in what case I learned about Glocks. Certainly some homicide trial probably I learned how they operate, and there's where the magazine is put, and that you have to rack the slide to put a bullet in the chamber, and it just struck me as nonsense, frankly, that somebody would not know a Glock 9mm has a round in the chamber and is loaded when they pick it up and point it, just because of the nature of the gun. And so regardless of who's standing where, whether they're on the bed or standing or whatever, those were things that sort of made it sound like, certainly Mr. Almeida's explanation to Dr. Zelig was implausible, and maybe this was verging on the edge of being more intentional. So what about those facts?
Well, Judge, I think that the fact that you have a shot from 18 inches or less, I don't think that makes a difference, quite frankly. Because we see all kinds of cases where, if you get on the internet and look up accidental shootings, and I'm not saying that this was an accident in the true sense of what we think of an accident is, all right? I think the conduct falls clearly within the murder 2 category. But if you look that up, police officers are accidentally shooting themselves frequently. Pro football players are shooting themselves frequently at close range. People have guns at close range. People play Russian roulette. People do all kinds of stupid ass things with guns. And they don't do them always from a distance. They do them close, they do them far. I don't think there's anything to say just because of the distance that it's intentional or not. What if there's no stipple? The shots from more than 18 inches then maybe with that gun. Does that mean it's not intentional? No. Does that mean it is intentional? No. I don't think the stipple tells you anything other than their stipple and the distance that the shot was fired from potentially. It doesn't tell you the behavior of the person or what's going on at that moment. So I disagree with that. The second one was, I'm sorry, Judge, what was the second one?
The nature of the weapon, having to rack the slide to load.
I don't know much about guns. I'm not a gun guy. And all I know is Dr. Zaley, when I talked to him about that, indicates that you can take that magazine out and still have a round in the chamber and put the magazine back in. You don't have to rack it. You can still have a round in the chamber with a Glock, and you can still fire it at that point. That's the information I got. He was a police officer for 25 years. He said he's very familiar with this type of gun. That's the information I have. So that's the only answer that I can give you, is that he may have not known that there was a round in there. Or I guess, Judge, the other alternative is he racks it and doesn't remember it, or he racks it and remembers it. I don't know. None of us were there that day. We're all speculating about what happened and how this offense is either a murder 1 or a murder 2 in this particular case. I don't think the physical evidence supports what the state is arguing to make this a murder 1 in this case. I just am not seeing this. It clearly is murder 2. The remote underneath her, I don't have any idea how it got there, but I'm going to tell you, based on the reconstruction in the other case that we did and what I've learned, I now really don't understand how lots of things occurred in cases, and we try to analyze them, and we just don't know. I don't know why that remote's there. I don't know what it means. I don't know how it got there. We can speculate, but I don't think anybody really knows. Maybe a crime scene reconstruction expert and looking at the blood and the bloodstain patterns and the location of them and the location where the state says she was, and what kind of blood, if any, is in those locations when her back was supposedly would have been facing to where all the blood is that what really happened? I don't know. I wasn't there. But it seems to me that there is differences in the evidence and what the evidence shows in this particular case. So I also don't believe that the state is correct that somehow Josh shoots and he's calm and he's just kind of figuring out what's going on downstairs. What do I do now? I'll wait a while, and then suddenly I'm going to make this frantic call to my mother and to 911. I don't think that's realistic to take place. I think that the shooting happened. He called his mother for whatever reason. She doesn't hear it. It's a 3-story house. She's upstairs. If you've ever seen that house, she's upstairs, down a hallway, in another bedroom. They're 3 stories down, behind a door in another bedroom. I don't know why the shot doesn't get heard. It does not get heard. That does not mean she's in the sauna. That does not mean she's in the shower. She may just not have heard the shot. For whatever reason, she didn't hear the shot. I don't think it's conceivable to say Josh does this. He's kind of chilling down there for some period of time and then freaks out and then calls 911. And you hear that on 911. That is not the typical call you hear from someone who's intentionally murdered somebody, who's done a cold, calculated, I think the way the state said it in their sentencing memorandum, it's a cold, callous, calculated act, and then you get a phone call like that. That's not typically what we see in a domestic violence case after someone's just murdered somebody. They're usually not just freaking out like he's freaking out. So I don't think the evidence supports the state's theory. The times are what the times are, but I don't think it supports the state's theory, and there's no physical evidence to support that in this case. The smudge on the thigh, we don't know if the police caused that. We don't know if Josh caused that. We don't know if it's him touching the body or moving. We don't know if her body's in that position because of what he was doing to the body before.
Yeah, I only asked about it because Mr. Myovis submitted the photo.
Sure.
I didn't know why he submitted the photo.
Sure, but what he's arguing is the way the body fell in that position. We don't know if Josh had done something in cradling her in some fashion that she's that way. If you sit her up, it wouldn't be inconceivable that she's sitting up in bed with her head up against the backboard of the bed or the wall with her back there like anybody else would be sitting up in bed. So I don't think that it supports it. I don't think the physical evidence, the blood stains, the crime scene, I don't think any of it support that. There's nothing to indicate there was a brawl going on in the bedroom. There's not things strewn about. There's not things broken, knocked over. When you look at the autopsy, the only injury to Bree was a gunshot wound. There's no physical injuries on her, on any other part of her body showing that she's been physically beaten. There's no bruising. Mr. Almeida's hands and body are looked at. There's no injuries to his hands as if he's been punching somebody or doing anything. So I don't think this supports a murder one. I think it's reckless conduct that was going on in there, and as a result of reckless conduct, she ended up dead.
Never mind.
Now, I know Mr. Myovis's theory has always been, and he added to his theory once he talked to Dr. Zelig. His theory has always been that Josh threatened her to get his bottle of alcohol back. Now, that was a theory they made with the 404B arguments, Judge. Let me back up even. If the state had evidence that Bree was being physically abused, there's no doubt that Josh, according to, I think even a jerk is not the right word. I think he was being an asshole to her on several occasions when they were texting, and I think that is clear that that's his borderline personality disorder on those. But if the state was going to argue that they had been in an abusive relationship and there has been physical injuries, we know the woman that got up here today that worked with her. My understanding is she traveled from out of town to be here, according to Ms. Taylor, but it turns out she works with her. She wasn't a family member, so technically she shouldn't even have been up here, but regardless, Mr. Myovis hasn't presented any evidence to you at the 404B hearing that there was ongoing physical abuse. He didn't call any witnesses here today to tell you that's been occurring. And that's because there's no evidence of it that he has. He has police officers that did follow-up investigation. OVR has an investigator. They can send out and get this information. OVR didn't do anything like that. There is not strong evidence here of an ongoing abusive physical relationship in that manner in this case. There is evidence of Josh's BPD in their text messages for sure, and that's what Dr. Zelig said. I don't think Dr. Zelig was saying those weren't important. I thought I had sent them to him. Apparently I had not. I had given him a complete copy of the file. He also had all the transcripts of, I gave him a complete copy of everything you got, plus everything else in the case. I thought I had sent him that. There's no way I would intentionally leave out the text messages. They're an important piece of evidence in this case. But he did get them and look at them and said, those are just examples of his BPD that are going on. So
Dr. Zelig was very careful in his testimony, in my view, to always say that he didn't find there was any physical abuse.
correct.
But the pattern of Mr. Almeida's conduct, at least in part in some of his relationships with his former girlfriends, wasn't necessarily one of physical abuse, but that he could be emotionally abusive and controlling by his own behavior. For example, I don't know this, I can't remember the specifics. I know I made findings in my order, but the photograph of the gun and the horse or something, and then the whole thing with one girlfriend about I'm going to kill myself and come over and save me, and then he has to sleep with the gun under his pillow. That's not being physically abusive, but in a relationship that can certainly be emotionally abusive. And certainly some of the language that he was using in the emails with Ms. Moore was abusive.
Is your question,
Well, my
Is
question
there
is,
evidence of domestic violence?
why must there have been evidence of physical abuse?
I think you could have, I've never said you can't have domestic violence that's non-physical, Judge. I don't think I've ever taken that position in this case. I think when we were discussing the 404B hearing in and of itself, Mr. Myovis raised that issue. I don't think I ever disputed that. I don't think I've ever disputed that. I've never taken the position in this case or now or ever that domestic violence is only physical abuse.
Okay.
All I'm simply saying is there was no evidence of physical abuse in this case in the relationship with my client and Ms. Moore. That's all I'm saying. Were there other things that are part of his BPD that made him act in certain ways, and could that also be viewed as domestic violence? Yes.
Okay.
Yes.
All right.
Now, Judge, when you were doing the 404B hearing, your ruling in that case, you made some statements in there. And I've got quotes from Judge, and I'll tell you the page number too. First, you said the use of alcohol during a domestic violence incident is the norm. That's a quote from you. You said Mr. Almeida's alcohol use, let me read it correctly. Almeida's prior drinking history with his ex-girlfriends did not involve instances where he was prone to violence when his access to alcohol was restricted. That's a finding that you've made in this case regarding that. Almeida's prior use of alcohol does little to show that he wanted to obtain alcohol for more at the point of a gun. These are all quotes from your order, Judge. The state's proffered motive is not supported by any evidence other than the fact a bottle was found under the bed. And because of this, the probative value of the evidence is weak. Those are findings that you made, Judge, regarding the state's theory in this case very early on. And I think those are findings that are still applicable today. The mere fact there's a bottle of alcohol under the bed, that doesn't mean she's hiding it. It could have got dropped, kicked, it could have ended up there in a number of ways. So we don't know how that bottle ends up there. So I don't think there's any evidence to support that she was taking that bottle away from him and hiding that bottle on this particular evening. She does say, I don't like the way you are when you drink in previous texts, but there's nothing to indicate that that particular evening that she took that bottle away and slid it. And if you look at the pictures, it's just barely under the bed. And I think Miss Almeida would have testified there was a knife under the bed. And she took that knife away, just like she took the gun away and she hid stuff. So I think you've already made findings as to that previously and found that to be significantly weak and not supported by the evidence in this particular case. So I don't think, I guess I come back full circle, we could sit here all day and argue about what the evidence means or doesn't mean. I don't think you have all the evidence either. You're just hearing what both of us are deciding to talk about. I don't think you even have all the evidence in the case to really look at it, to make an adequate decision as to whether this is a first-degree murder case or not here. So I don't think you can actually make that finding because you don't have all the information to make the finding. And the state did not bring in and put on all the evidence. They didn't call a single witness to support their theory that it's a first-degree murder. They've just argued what a small portion of the evidence is in this particular case. So I don't think you can make that finding that this is a most serious or a worst offender based on the conduct alone in this particular case. When I was looking at, worst offenders, and I was thinking about this, Judge, quite frankly, in almost, I would say the majority of my cases that I do of this nature, and I've done a lot in the last 30 years, and I do mostly serious violent crimes type cases. It's almost all of them have some aspect of substance abuse or substance involved on that occasion. Almost all of them have some sort of mental illness in some aspect or both. I mean, we see that frequently. Every person that dies at the hands of the other is horrible. And some of them are much more worse than others. It's not, rape murders can be worse. I mean, bodies are stabbed multiple times, people are burned, they're drowned, they're thrown out windows. There's a whole, bodies are taken and hidden, they're dismembered. There's a whole host of bad things that go on out there, Judge, that we look at. And this is a single gunshot wound. A single gunshot wound that unfortunately happened and brought a very lovely young woman's life to an end. But this is not the type of case that is the most serious type of case that we see or that you have seen. And the conduct in here that we see, well, and I'm not trying to justify it by any means, but the conduct for sure is a typical type of conduct we see in the majority of the cases we have in front of us. I would say then you could probably find a worst offender in almost every case. You could simply say, based on the conduct that occurred in this case, worst offender. Based on the history of the person, worst offender. And we know the Court of Appeals is likely to uphold it. So I don't think I think you really have to carefully look at this and say, is this really, when I look at other cases that I've done historically in my career, is this really a worst offender type situation here? Based on the history of him or based on the facts of the case or both. And I just don't see it compared to other cases that I've done and other cases I have watched through this courtroom and courthouse for the last 30 years, Judge. As far as a parole restriction goes, I think that as far as a parole restriction goes, Judge, I want to talk a little bit about that, and that's in conjunction with Dr. Zalig's testimony too. I put Dr. Zalig on the stand knowing that he was going to say Joshua is still dangerous and is likely to reoffend in the next 10 years if he's with or without treatment. I knew he was going to say that. I could have easily made the decision not to put him on the stand and not to have any of this testimony and nothing regarding his borderline personality disorder brought to this court's attention. I didn't think that was the right answer in this particular case. I don't think anybody is standing here in this courtroom saying Josh should be released right now. We're trying to predict as best we can into the future. We're trying to look at that. And we try to look at it now through a lens. We try to look through our lens. We don't look at any of this through his lens, although I think his lens is important to take a look at it. We try to look at it from the family side of it, but we often forget there's a family on the other side of it. And I think when we're looking at Dr. Zalig, what Dr. Zalig said is, listen, right now, he should not be released. He's a dangerous person. But when we look at the DSM-5, the DSM-5 is a manual that is used by clinicians throughout the world. And when you look at the DSM-5, it's very clear that in their view, and Dr. Zalig said this is a conservative view in his point, that 50% of the people after 10 years essentially don't have BPD. Now, I know there's a big argument by Mr. Myovis. That just means they have traits, but they don't have all the traits. But I don't think that's really the argument. I think what the DSM-5 says is that as people get into their 30s and 40s, they get more stable, their life gets more manageable, and these symptoms decrease and they get better. And in fact, they get to the point where they're fine and they live normal, productive, healthy lives. Dr. Zelig provided you with 2 of the 3 studies that you have. 2 of them are from Dr. Zelig. And the other one is from Mr. Myovis.
One of the studies I was provided, though, I don't know who gave it to me, it's one of the ones I took home last night, says that the worst mix is BPD, alcohol, and a bad childhood history. Now, Mr. Almeida doesn't have a bad childhood history, but he's got BPD and an alcohol history. And goes on to say, really what you ought to look at is
I think that's the article that talks about antisocial personality, alcohol.
it talks about BPD and antisocial
No, I know.
personality.
That's the article that actually Mr. Myovis withdrew.
Predicated on the fact that he doesn't have the disturbed childhood that article was talking about. I was going to provide it in the context of discussing other aspects of it, but I agreed because he didn't have a bad childhood that I just withdrew it.
And he,
Okay.
and he does not have antisocial personality disorder.
Okay.
That has been ruled out. So we know that he has a dual diagnosis of substance abuse, and he's got a bad substance abuse. There's no question about it. I'm not standing here saying it's not. He's got bipolar, and then we know he has dysthymia, which causes him to have the flat effect that everybody, I believe, is mistaken for lack of remorse. So Dr. Zelig's position, which is supported by the DSM-5, which is relied on by courts frequently, relied on by clinicians around the world, as well as the studies that you've been provided show that BPD really remits in 70 to 75% of the population as they enter their 30s and 40s. So as Josh gets older, and the longitudinal studies that were provided you show over a 6-year course, it got 70 to 75% better. The DSM says over 10 years. But I think the studies, the point I'm getting at is when you look at those studies, they reference other longitudinal studies in there that discuss BPD over the long haul. I think some of them were 10, 15, and 20 or 25 years they looked at them. And those all showed remissions, and the people lived a perfectly fine life. Now, Dr. Zelig says the biggest factor here is getting his substance abuse in order. He's got to get his substance abuse in order. If he gets his substance abuse in order, he's going to be totally fine, because in all likelihood, what the studies are showing and what the DSM-5 shows is that he's going to get better with or without treatment. And he's likely going to get much better with some treatment over the period of time. But even without treatment, we know that the studies and the DSM-5 show that he's going to get better. Now, do we guarantee that he's going to be not in the 25%? No. You could order a psychological evaluation be done later on. So that could be available to a parole board. There's nothing precluding you from doing that. There's no difference in the probation officer recommending inpatient or things that are offered by the jail. Right now, he's in Cook Inlet. There's nothing offered there. We're complaining that he hasn't done anything because he can't do anything. There's not really much to do there. At this point in time, he's got to get to someplace where he's going to be housed for a long period of time before he can start doing something. So I think you have to look into the future in that and say, you know, the anger dissipates, the impulsivity and the substance abuse are the two that dissipate the fastest. The anger dissipates over time, as well as they learn coping skills and they learn how to deal with things, and they get cognitive therapy, and it teaches them how to redirect. So I'm not trying to say, Judge, that rehabilitation is the first and foremost thing. What I am saying is that he has not really had any type of psychiatric treatment, so we don't really know if it's going to take or not. I suspect with what Dr. Zelig said, and he's very knowledgeable in the area, it's likely to work. The We know that Volunteers of America is an educational-based program. And we know that Aquila House can be an educational-based program. He got a substance abuse evaluation. And maybe it was a joke, because maybe they weren't teaching him anything. And maybe that's a fair statement to say, that these programs are jokes. And they didn't help him because they weren't the right type of program that he needed. I'm saying that you should not ignore rehabilitation as a significant factor here, because we just don't really know, and now we really know what the problems are besides alcohol. It wasn't just alcohol, even though that seems to be the main issue. So I think that's something that you really need to take in consideration here in making any decision. I don't have any disagreement that the remainder of, anytime we're in here in a situation like this where they've got a prior history, even if they don't, and you have a person that's died, you always are in a situation where all the rest of the Cheney criteria always apply. I mean, that's why they're there. They always apply in these type of cases. And I don't think that I think they're probably equally applicable. And then I think the isolation component of it gets dealt with because we know that mandatory minimum's 10. We know anything between 10 and 20 has been disapproved by the Court of Appeals. We know you're not going to give a sentence there. We know the sentence that in Page says start at 20 to 30 years. It's unlikely you're going to give a sentence of 20 to 30 years to serve. All right? It's likely that you're going to give a higher sentence. When I looked at all the murder 2 cases, I read every one of them. I found 128 of them. 14 of them gave 99-year sentences of 128, and 10 of them gave parole restrictions. So they don't often occur in them. And 2 of the parole restriction cases, and I did one of them, was Ray Cheeley, was reversed. And so I think that in this particular case, I don't think the argument that the parole board doesn't have any accountability because they can't be sued is a valid argument. I don't think the parole board is willy-nilly just gonna go, you know what? We don't give a damn if this guy's crazy and he's gonna go out and kill people. We can't be sued. I don't think the parole board looks at that at all. I think the parole board looks and says, is this person eligible for discretionary parole? What needs to be done if he is eligible for discretionary parole, and can he live safely in the community and not be a danger to the public? And I think the parole board will do that, and I think with him, now that we know what the issues are and he can get somewhere and hopefully deal at least maybe with substance abuse while he's in there, the family's going to see if they can get someone to come in to deal with the BPD. I don't know if that's possible. We know that it remits over the course of time. We know that he's going to be in there into those time frames where they remit. We know that he's going to be required to get some treatment upon going out into the community again. He's going to have alcohol. He's going to have psychiatric treatment. There's no reason you couldn't order that he get a mental health evaluation later on down the road when he's eligible for discretionary parole and see where they're at. That certainly helps the parole board to do that. I think the parole board is in the best position in the future to make a decision of what happens with him, and does Josh sort of outgrow some of this stuff, and does he sort of get his act together on the alcohol? So I think the parole board is actually in a better position to figure this out than us trying to figure it out now, what's going to happen in 20 to 30 years. So even if you gave a 60-year sentence and he serves 20 before he's eligible for discretionary parole, as an example, he's going to be 45, 43. So he's going to be right in where the DSM-5, the studies, and Dr. Zelig say it remits in people at that age. He can also get the psychiatric evaluation that needs to be done. So the parole board has something to look at then. If he's got to serve, extra 10 years, it's 30, the same thing. He's going to be in his 50s then. We don't know if the bill that the state is talking about is going to pass. So we don't have any idea. So we shouldn't be going, what if this bill passes? What if that bill passes? We have to deal with what's the law today. And we don't know what that bill, and that bill may change something, it may not. I don't know. So I think in the long run, Judge, that a sentence probably in the mid-range, when I look at these murder 2 cases, a sentence in the mid-range with his background and the type of offense that occurred here is a pretty common sentence that you give, and the courts have given when you look at them. I just don't see this as a murder 1. I don't see this as a 99. I don't see this as a parole restriction. type case, and I don't see it as a worst offense, most serious, based on the facts and circumstances and the evidence they all have before the court. I don't know if you have any other questions, Judge.
I do. I have not addressed a parole restriction since State versus Corcow was issued in 2013. And I used to think of a parole restriction mostly in terms of public protection and the lack of rehabilitation potential. But what the court said in that case is that a sentencing court must consider all of the enumerated criteria in AS 1255-005, which are the Cheney criteria, when restricting discretionary parole as part of a sentence, not just public protection and the defendant's reformation. And both of you have been arguing the latter, really, in addressing parole restriction. If, when I look at all of the Cheney criteria, it warrants imposing a sentence at the higher end of the range, does that mean it also warrants imposing a parole restriction? Of course, the converse would be true, but I'm asking you the former question.
I don't think so. I don't think that just because if you decide to do a higher end sentence, whatever that end is, that you automatically do a parole restriction along with it. I don't think that's what the case law says. I don't think that's how the statute reads. I think it's completely 100% discretionary on your part. But I think you come back to the argument I make, is that you can put a parole restriction in every one of these cases. So I don't know if Corcow really gives us really a lot of good guidance as to, when to give one and when not to give one, to be honest with you. The history before was you always looked at, was it needed to protect the
I
public?
think it says, I don't presume the parole board knows any better.
No, I think they said there's no presumption. I agree. I think the case law is pretty clear. I think Mr. Maiovis and I outlined the case law pretty clear, but I don't think it mandatorily warrants a parole restriction. I think it's still completely discretionary to do a parole restriction or not do a parole restriction. And I still think you could make findings that I think the parole board is in the better position to do that. I don't think that would be an error for you to say, based on the information we have in this case, and if I order a psych eval when he's eligible for discretionary, I don't think that would be anything would be wrong with that, or you couldn't do that in any way. But the concern I have is that you could always ask for parole restriction. You could ask for them in just about every single case that involves this or sex abuse or sex assault.
Mr. Maiovis, I have a question of you.
Can I just address very briefly the last point you just
Yeah.
raised with Mr. Lambert, because Judge, I think that I did a much more thorough outlining of that issue in my sentencing memorandum, and I did only focus on, as you pointed out, the very, what would be considered the old law when addressing the court. I think that your points are well taken, and one of the things I've said a couple times in my presentation that applies here is that I didn't address in my oral argument to you all of the Cheney criteria, because I think that I laid it out in my brief and the other people have addressed it. I think that it is the totality of the Cheney criteria that would warrant considering that particular thing, and in light of the fact that unlike what would traditionally be the situation before Corcow, the Court of Appeals has made it clear that rehabilitation is not, in certain circumstances like this, is not even one of the higher goals that a sentencing court can consider when making the determination about an appropriate sentence, which would include whether or not a parole restriction should be imposed. So I think I did a more thorough job in my brief, but you're right in my addressing the court in today's argument. I actually focused on the things that you mentioned.
My question to you was something that Mr. Lambert raised, and that was that I don't really have enough information to make a most serious finding here, because you've thrown a lot of information at me, but case hasn't been really tried in front of me. And it's true that a lot of the time, certainly in homicide cases where I'm used to making a finding, oh yeah, well, the jury returned a murder 2, but I really think this was a murder 1. I've sat in front of, and heard 3 or 4 weeks worth of testimony, and that's not true here.
Well, Judge, I wrote down one thing when Mr. Lambert was speaking, and my one thing is, didn't call any witnesses. There's a very specific reason for that, Judge, and maybe you'll recall this. Mr. Lambert and I agreed that we didn't need to have a 2-week sentencing in this case because we were both going to agree that we could provide you with any of the evidence that was provided in discovery and make our arguments based on that. And that's what I've done. I've provided you with, I think, what the relevant evidence is. That was an agreement we made. To say that I didn't call witnesses, I could have wasted 2 weeks of your time, Judge, but we made an agreement that that wouldn't be necessary here. That was predicated on why we selected 2 days for sentencing. I think at this point to say that I haven't made the case, I've provided you with all of the evidence I think you do need in the attachments to my sentencing memorandum and the additional things that I provided you. There's no smoking gun outside of that material that I provided you that you're not taking into consideration. I could have provided you with a 1.5 worth of text. That was a representative sample. So that's what I've done. I believe that you do have sufficient evidence to understand what's going on in this situation, Judge.
Okay. Mr. Almeida, I'm sure I'm sure your attorney has explained that at sentencing you have the right to talk to me personally and say anything that you'd like to say and have me consider. You don't have to. I'll certainly listen to anything you wish to tell me. Now's the time for you to do it. You don't need to get up to the podium. You can just sit there if you wish. So if you'd like to make a statement to me or read a statement, you can. Sure call.
I'm going to do both, Your Honor.
Okay.
No one in this courtroom knows how I feel. And just because I don't show up, I have a hard time showing emotion, does not mean I do not hurt. And it pains me to sit here and listen to Mr. Maiovis and everyone that has spoken to attempt to tell the court of who I am and how my relationship with 3AN was. When they do not know me, and they did not know our relationship, and they cannot tell you what happened that night. But there isn't a day that goes by that I do not think about Brianna. And I live and carry with that burden with me, and heartache every day. And no one will understand how that truly feels. Our love has been lost. Our love has been taken to be replaced by mourning and the seeking of answers to questions that don't apply, causing more hurt than one should bear on either side of attached parties. How does one begin to grasp the cause at thing? The effects have yet to be fully understood. Heart's emotions are in such disarray due to the amount of pain and loss. Can a word or adage be said to convey tragedy so great? Confusion consumes the thought process. No amount of physical pain can be compared to the ache of absence now felt. The love of one's heart can never again embark in expressed emotion, wrought to an end in this untimely event, only to set sail to the misunderstanding and loss of another. When does healing begin? When can the ire abate so truth can be seen? Never was intent a factor. Somehow her presence gave purpose for life. A presence that formulated drive and a sense of esteemed honor. Her purpose became my cause, my bearing, and my hope. A hope not to end, but rather begin. Aspiration of prosperity and success at the helm of our lives. The significance of happiness found in a set of blonde curls, only now to be publicly bellied through social media and local newscasts. Parties never before seen or influenced now feel some obligation not to acquire account, but rather assume intent. How can one in a state of such loss fabricate tales of abuse and relational oppression? Their disgruntled thoughts have warped themselves around this calamity. How can time's expedient to event be wasted through the persistent degradation of another? When truth should be sought, instead a cloak has now veiled the unseen reality of Brianna's life. Her true emotional distress, hidden for reasons unknown. Truth can never be seen through the eyes of persecution or personal retribution. I will no longer stand here in derision, for kin and opposed parties are not alone in pain so unbearable. I now live with the loss of the love of my life, the loss of a planned future and memories marred by unintentional, reckless error. Words cannot be found to describe the shame, the remorse, the pain that now fills my heart. As if personal error wasn't enough to bear, now to be combated with lies and false accusations of abuse. Although personal views may never agree, one thing is for sure. Brianna was and is loved by all affected. I am deeply apologetic for the loss of life and pray wholeheartedly for forgiveness from the Moors and the mercy of the courts. Your Honor, nothing I can say or do will change what I have done. I stand before you with sorrow and remorse in my heart. I am truly sorry for my actions that night in June of 2014 when I took the life of the girl I could not live without. A wonderful, beautiful, innocent Brianna. I was under the influence of alcohol, and I realized this is by no means an excuse or justification for my actions. I drank by my own free will. This is my fault and no one else's. I am simply looking to explain to the court what happened that dreadful night. It was an ordinary day. I woke up that morning and got ready for work. It ended up being a slow day, so I decided to leave early, sometime around 1:30 or 2. I drove back up to my parents' house to relax before treatment at 6:30 that afternoon. Brianna got off work and drove up to the house. We hung out for a little bit, then she drove me to Aquila before she went to her parents' house. Brianna picked me up around 8:45. While we were driving home, we stopped at a Tesoro on Abbott to get gas. At that time, I decided to go inside to buy a fifth of Captain Morgan. After that, we proceeded to drive up to my parents' house. When we got home, I took the dogs out while Brianna went inside to talk to my mother. I came inside and saw that Mom had already made dinner. I asked Brianna if she wanted to eat. She said she ate at her parents' house, so she went downstairs. After I finished eating, I cleaned up my mess, locked the doors, and set the alarm. I said goodnight to Mom, who was doing some schoolwork, and went downstairs to join Brianna. When I got downstairs, I noticed Brianna was in the shower, so I decided to grab the pillows and blankets from the living room and brought them, or from my room, and brought them to the living room where we were going to watch one of the movies that we bought earlier in the week. Brianna was in the bathroom, so I put in the movie she picked out. While I was waiting for Brianna to finish up in the bathroom, that's when I decided to start drinking. By the time Brianna joined me on the couch, I was already halfway through the bottle. We started the movie, and shortly after, everything went dark. I came out of my blackout and was still on the couch. The same movie was playing, but I saw that I had my gun on the coffee table in front of me, broken down in pieces. Rand was next to me looking through my MRT booklet from Aquila, asking me questions and talking with me while I was cleaning my gun. I was showing Brianna how to take it apart and put it back together. And everything went dark again. I came to this time. Brianna and I were in my bedroom. She was in bed on her side, sitting up, talking with me. Brianna asked me to stop playing with my gun and put it away and come to bed, because I had it on me while we were talking. I told her, "Do not worry, the gun is not loaded." Then I pointed the gun at her, not knowing it was loaded, and pulled the trigger. The gun went off. I stood in shock. I rushed to her side to see if she was okay. I grabbed her by her shoulders, looked into her eyes, and knew Brianna was gone. I lost it. I started screaming for my mom to call the ambulance, and everything went black. I woke up 4 hours later, cuffed, and sitting in a cold room at a police station. 2 detectives came into the room shortly after. The severity of the implication and the questions being asked were overwhelming. I was scared and was not in the right state of mind to comprehend what had happened. So I lied to the detectives and told them that I was in the bathroom when the gun went off, out of fear. First time I met with Mr. Lambert, I disclosed with him what had truly happened that night. I later on told the Moores of the same tragic event, and I had a sit-down meeting with them. Your Honor, it was never my intention to cause harm to anyone that day the shooting happened. Due to my alcohol consumption, I was careless, I failed, and inadvertently and accidentally caused Brianna's death. I was involved. I cannot argue that fact. I can only ask you and everyone else to change the lens in which you look at the circumstances. I never meant for this to happen. This is something I'm going to carry with me forever. And like any burden, it gets heavier and heavier, except I will never be able to put it down, because now it is a part of who I am. I let this happen. There are no excuses for my poor choices. All of our worlds were turned upside down that day. Because of my actions, no one deserves what happened. I deeply regret and am sorry for my actions that night. I'd give anything to have Brianna back. I'm sorry I took your daughter and granddaughter, sister, and friend away from you. I recognize and understand the scope of damage that I caused. I've apologized to the Moores, Your Honor, and again I publicly apologize for the terrible pain I have caused. I'm truly sorry. It is my hope that someday they can forgive me for what I did and help from the damage that I caused. I would also like to apologize to my family, Your Honor, because they were just as surprised as everyone else by my actions and are also victims of this unspeakable tragedy. It does not make it hurt any less for them. They love Brandon like their own daughter. They have found that grace and forgiveness is better than bitterness, and I am forever thankful to have their love and support. I have found that you still function when your heart is being torn to shreds. But there's this hole so deep inside, but there is no visible end to this. This is something none of us will never ever get over, and for that, I'm sincerely remorseful. Your Honor, I need treatment, and wherever I go, I'm going to utilize every program that DOC offers to try and better myself. I don't want this time that I get, or this sentence, to be for a waste. Thank you.
Ladies and gentlemen, it's 3:30. We're going to have to take a break here. First of all, because regardless of whether or not we can finish today, I'm going to need some time to at least collect my thoughts and then check on some additional things in terms of today's schedule and resources. So I don't want to bring you all back in until 4, and then I can let you know whether we can finish today. Council, and by that I want to include Ms. Winston. I'd like you to remain for a minute after everybody else is cleared out, so I can talk to you about my schedule. Okay?